lecture is about constitutional morality, which is used as a tool by apex court in many cases in determining the validity of laws. In India, one often hears about public morality in a constitutional rhetoric, and hardly anything is heard till very recently about this, that is, the constitutional morality. Though Constituent Assembly debates mention constitutional morality, its meaning and importance were not discussed in as much detail. Constitutional morality could be simply understood as adherence to core constitutional values. Thus, understood whether this doctrine is similar to the doctrine of basic structure, this confusion exists in the mind of many. This word was first used by Dr. Ambedkar during the Constituent Assembly debates to justify the inclusion of administrative details in the Constitution itself. On that occasion, he said, I quote, that it is only where the people are saturated with constitutional morality, such as the one described by Grote, the English historian, that one can take the risk of omitting from Constitution details of administration and leaving it for the legislature to prescribe them. Unquote. The doctrine of constitutional morality is not a new concept and traces its origin back to the work of English historian George Grote. He described the phrase in the context of the history of Greece, Athenian democracy, and the perils surrounding it. Why is constitutional morality important? In 1946, when Grote wrote about the rise and fall of Athenian democracy, he explained that the diffusion of sentiment of constitutional morality throughout society is a prerequisite for a stable, peaceful, and free society. The morality referred to includes the acceptance by both the state and society of the universality of human rights. He used constitutional morality to describe popular sovereignty based on freedom and self-restraint. Constitutional morality for Grote also meant citizens' right to criticize public officials. Therefore, highlighting the limitation on the power of public officials and their duty to respect the Constitution. Today, the meaning and connotation of the phrase have acquired newer interpretations. After a couple of mentions in the Constituent Assembly debates, not much significance was given to this doctrine by the Indian judiciary during its early years. Although few references to constitutional morality could be found in certain judgments, most of them lacked substance and did not realize the meaning of constitutional morality entirely. Thus, two judges in Keshavananda Bharati versus State of Kerala judgment had invoked constitutional morality but did not elaborate it. In S.P. Gupta case, another judge described constitutional violation as a serious breach of constitutional morality. Although not formally recognized as a consistent doctrine, its addition and interpretation facilitated some of the most important and liberal judgments over the past few years. Thus, in 2014, in a number of cases, judges frequently refer to constitutional morality. In Manoj Narula versus Union of India, the Supreme Court had to decide if a person with a criminal background could be prevented from becoming a minister in the central or state governments. Justice Deepak Mishra referred to Baba Saheb Ambedkar's speech in the Constituent Assembly on constitutional morality. In describing the meaning of constitutional morality as understood by the bench, he said, I quote, constitutional morality means to bow down to the norms of the Constitution and not to act in a manner which would become violative of the rule of law or reflectable of action in an arbitrary manner. It, along with commitment to the Constitution, is a facet of constitutional morality, unquote. In another important case, that is NCT of Delhi versus Union of India, the Supreme Court presented a somewhat different interpretation of a constitutional morality. The court equated constitutional morality with the spirit of the Constitution itself, which is quite similar to the basic structure doctrine. Justice Deepak Mishra wrote, I quote, constitutional morality in its strictest sense implies a strict and complete adherence to the constitutional principles as enshrined in the various segments of the document. It is required that all constitutional functionaries to cultivate and develop a spirit of constitutionalism where every action taken by them is governed by and is in strict conformity with the basic tenets of the Constitution, unquote. Here, one can draw a parallel between the principle of constitutional morality and the basic structure doctrine. But another series of judgments gave a different interpretation of constitutional morality. These judgments saw constitutional morality as remedying public morality. Public morality refers to prevailing notions of rights and wrongs in the society. In a Naz Foundation judgment, the Delhi High Court rejected public morality as a compelling state interest that could justify restrictions imposed on personal liberty as Article 21 of the Constitution provided. The court here also differentiated public morality and constitutional morality. Unlike constitutional morality, the court added that popular morality was based on shifting and subjective notions of right and wrong. The court also argued that for compelling state interest, the court must consider constitutional and not public morality. The Chief Justice here used constitutional morality as a tool to counter the temporary notion of morality as held by the majority. The court explained that the morality it enforces is that which is espoused in the Constitution, and that when assessing the rights violations imposed by the criminalization of consensual same-sex sexual acts, public disgust cannot be a reason to justify discrimination against a social group. Then the Supreme Court in Suresh Kumar Kaushal versus Naz Foundation set aside the High Court decision in the Naz Foundation case, causing considerable discomfort in the judiciary. In Independent Thought versus Union of India, then the Supreme Court struck down the second exception of Section 375 of the Indian Penal Code. The exception dictated that a man who has sexual intercourse with his wife who is 15 years of age or over does not commit rape. While the reading down this provision, the court used this doctrine of constitutional morality. It said, I quote, constitutional morality forbids us from giving an interpretation to exception 2 to section 375 IPC that sanctifies a tradition or custom that is no longer sustainable. In this case, the principle of constitutional morality was applied to counter the prevailing societal norms, which consider women as property of men with no sexual and bodily autonomy. Eventually, the Kaushal decision was overturned by the Supreme Court in 2018 in Navtej Singh Johar's case, where the Chief Justice Deepak Mishra criticized the Kaushal decision as having been guided by social morality leaning on majoritarian perception, whereas the issue in actuality needed to be debated upon in the backdrop of constitutional morality. The Supreme Court explained that what the Kaushal decision did not grasp was that fundamental rights do not require majoritarian sanction, and that to try to promote homogeneity in society would violate the principle of constitutional morality. The court held, I quote, there is at present time a growing tendency throughout the country to disregard constitutional morality. On all sides, we find impatience with the constitutional restraints, manifesting itself in many forms and under many pretenses, and particularly with the actions of the courts in protecting the individual and the minority against unconstitutional enactments favoring one class at the expense of another. Unquote. In this case, Justice Chandrachud, while distinguishing between constitutional and public morality, recognized society's popular notions and its shadow on laws. On the other hand, constitutional morality requires that the rights of an individual should not be affected by these popular notions. Further, he elaborated that constitutional morality reflects that the ideal of justice is an overriding factor in the struggle for existence over any notion of social acceptance. Three judges held that the judiciary needs to transform society to convert public morality into constitutional morality. Next, in the Joseph Shine case, the court struck down Section 497 of the Indian Penal Code. This section of the IPC selectively criminalized a man for having sexual intercourse with a married woman. Justice Chandrachud found that this section was based on the 19th century's social and sexual convention, which disregarded women's sexual autonomy and considered her as husband's exclusive possession or property. He rejected this notion and said, I quote, "It is not the common morality of the state at any time in history, but rather constitutional morality which must guide the law." Interestingly, in the Sabarimala case, constitutional morality was a common doctrine among the majority, which allowed the relief, and a minority view which declined the relief. The judgment dealt with whether women aged between 10 to 50 years old could be denied entry into the Sabarimala temple sanctum sanctorum according to religious tradition and custom. The majority opinion delivered by Chief Justice Deepak Mishra, who observed, I quote, "The term morality occurring in Article 25(1) of the Constitution cannot be narrowed down and be viewed in terms of what it means to be an individual, a section, or religious sect. In cases where there is a violation of fundamental rights, the term morality naturally implies constitutional morality, and the Constitutional Court's decision must be in conformity with the basic principles of constitutional morality that emanates from the Constitution itself." Unquote. He added, I quote, "Having said so, the notions of public order, morality, and health cannot be used as colorable device to restrict the freedom to freely practice religion and discriminate against women of the age group of 10 to 50 years by denying them their legal right to enter and offer their prayers at the Sabarimala temple for the simple reason that public morality must yield to constitutional morality." Concurring with the majority view, Honorable Justice Chandrachud observed, I quote, "Constitutional morality is not subject to fleeting fancies of every time and age, but is deeply rooted in fundamental postulates of human liberty, equality, fraternity, and dignity. Freedom of religion, and likewise the freedom to manage the affairs of a religious denomination, is subject to and must yield to these fundamental notions of constitutional morality. In the public law conversations between religion and morality, it is the overarching sense of constitutional morality which has to prevail. However, Justice Indu Malhotra, differing with the majority view in her minority opinion, observed, I quote, "Equality and non-discrimination are certainly one facet of constitutional morality. However, the concept of equality and non-discrimination in matters of religion cannot be viewed in isolation. A balance is required to be struck between the principles of equality and non-discrimination on the one hand, and the protection of cherished liberties of faith, belief, and worship guaranteed by Article 25 and 26 to persons belonging to all religions in a secular polity on the other hand." Unquote. In this judgment, judges in majority and minority used the same principle to arrive at entirely different conclusions. Justice Mishra and Justice Chandrachud clearly said that public morality should give way to constitutional morality, and no religious denomination can use it to deny the women their legal right to pray at the temple. On the other hand, Justice Indi Malhotra spoke about harmonizing various rights guaranteed by the Constitution. Subsequently, several issues and criticisms were raised regarding this principle of constitutional morality. Many legal scholars do not share the views of judges who differentiate constitutional morality from public morality and have raised concerns regarding the apex court's understanding and application of the principle of constitutional morality. Thus, Attorney General of India, Shri K.K. Venugopal said, I quote, use of constitutional morality can be very, very dangerous and we cannot be sure where it will lead us to. I hope constitutional morality dies. Otherwise, our first Prime Minister Nehru's fear that Supreme Court will become the third chamber might come true. The Law Minister also took a critical view of the Supreme Court's usage of the principle of constitutional morality. The differing views expressed by various judges clearly indicate that as of now, there is no clear consensus regarding the content and contour of this principle. Due to this vagueness, the fear is that it would get subjected to personal values and biases of the judges. If this doctrine is used without any limit or restriction, many have feared that it could amount to judicial overreach. Senior Advocate Abhishek Manu Singhvi commented on the usage of the constitutional morality in the Sabarimala case. He said that phrase is full of subjectivity and the judicial approach to constitutional morality would vary from judge to judge. Therefore, a standard need to be set to avoid legal inconsistencies and arbitrariness. In Kantaro Rajivarao versus Indian Young Lawyers Association, the Supreme Court decided to refer to a larger bench on defining constitutional morality. The court observed that the expression is not defined anywhere in the Constitution and contours of this expression need to be delineated to prevent it from becoming subjective. Justice Naramin in the same case has very rightly asserted that the spirit of the Constitution forms constitutional morality. According to him, it consists of nothing but values inculcated in the Constitution contained in the preamble, read along with Part 3 and Part 4. By setting certain objective standards, the principle of constitutional morality could be developed as more reliable doctrine, such as the basic structure doctrine. Defining the meaning of constitutional morality clearly could make this a standard, especially in cases where the rights and liberties of individuals are pitted against religious or cultural practices. Lastly, it could be summed up that constitutional morality is not limited only to following the constitutional provisions literally, but is based on values like individual autonomy and liberty, equality without discrimination, recognition of identity with dignity, and the right to privacy. So with this, I conclude this lecture. Thank you.